So amending the Articles of Confederation was really hard, right? We learned that we needed 13 out of 13 states to agree to an amendment to the Articles of Confederation, and unanimity just presented way too high of a collective action challenge. However, amending it too easily would put us at risk for tyranny. So we didn't want people to be able to change the Constitution too easily, but we didn't want to make it too difficult. So the framers ultimately made this two-stage process, where amendments can be proposed by either 2/3 of both chambers of Congress or a constitutional convention called by Congress on the petition of 2/3 of the states. So basically, if either Congress or the states want an amendment to be proposed, there's a way for that to happen. Now, assuming they pass this barrier of 2/3 of both chambers or 2/3 of that special constitutional convention, we move on to stage 2. And that's where 3/4 of the state legislatures must ratify the amendment. So ratification just means then we're going to add it to the Constitution. And we can either have that 3/4 of the state legislatures or 3/4 of special constitutional conventions called by each state. So you notice stage 1 involves Congress. Stage 2, however, only involves the states. So much of the amendment process is left to the states. And in theory, it could be all the states if they petition Congress to call this special constitutional convention, though that has never happened. That's why those are little dotted lines on there. Even though it could happen, it has not. So we've always seen Congress proposing an amendment and the states ratifying them. In fact, it's always been 3/4 of the state legislatures, except for one time, the repeal of prohibition, when this happened through those special constitutional conventions within each state. The point of this really is that it is hard but not impossible, and that it mixes federal and state involvement, but gives states the final say. Because of course, under the Articles of Confederation, states had most of the power here. So the framers of the Constitution wanted to keep states involved and allow them power in this particular process. And you will notice that it is still a hard process. The Constitution's only been amended 27 times. There were 6 states that failed to hit that barrier for ratification, so they passed through Congress, but didn't get enough states to ratify. The Equal Rights Amendment fell just 1 state short. And tons of other amendments have been suggested in Congress. Very few even pass one chamber, and then many have failed then to pass the second chamber. Now, you'll notice through all this discussion, I've talked about the chambers of Congress and the states. I have never mentioned the president. That's because the president doesn't have any power to amend the Constitution. While he could, in theory, ask Congress to propose an amendment or try to get the public or states on board with an amendment, he has no actual power to propose or ratify an amendment to the Constitution. And the reason for this is really just to prevent someone from seizing too much power, from seeming like a tyrant or like the king that we had just recently fought a revolution against. So the idea here, the key takeaway, is that amending the Constitution is hard. There are a lot of collective action barriers here, but not as hard as it was under the Articles of Confederation, and that states have a key role, though the federal government, embodied by Congress in this case, has some power, while the president has none.